Ready, start. We respectfully concur with the above guidelines and while reaffirming the same comma, we would add that the order of the magistrate should be such which does not result in unnecessary harassment to the accused and at the same time does not cause any prejudice to the complainant full stop. In light of the afore extracted legal principles, the impugned order is clearly erroneous in as much as the discretion of the magistrate under section 205 of the code cannot be circumscribed by laying down any general directions in that behalf full stop in Manoj Narayan Agarwal versus Shashi Agarwal and others, this court, while observing that the High Court cannot lay down directions for the exercise of discretion by the magistrate under section 205 of the code, had echoed the following views. Similarly, the High Court should not have, for all intent and purport, issued the direction for grant of exemption from personal appearance full stop. Such a matter undoubtedly shall be left for the consideration before the learned magistrate full stop. We are sure that the magistrate would exercise his jurisdiction in a fair and judicious manner full stop. It is equally trite that the inherent powers of the High Court under Section 482 of the Code have to be exercised sparingly with circumspection, and in rare cases to correct patent illegalities or to prevent miscarriage of justice full stop. In Madhu Limaye versus the state of Maharashtra, a bench of 3 learned judges of this court had observed that the following principles may be noticed in relation to the exercise of the inherent power of the High Court, that the power is not to be restored to if there is a specific provision in the code for the redress of the grievance of the aggrieved party, that it should be exercised very sparingly to prevent abuse of process of any court or otherwise to secure the ends of justice, that it should not be exercised as against the express bar of law engrafted in any other provision of the code full stop. Similarly, while it is true that the power of superintendence conferred on the High Court under Article 227 of the Constitution of India is both administrative and judicial, but such power is to be exercised sparingly and only in appropriate cases in order to keep the subordinate courts within the bounds of their authority full stop. In any event, the power of superintendence cannot be exercised to influence the subordinate judiciary to pass any order or judgment in a particular manner full stop. In Jasbir Singh versus State of Punjab, this court observed that so, even while invoking the provisions of Article 227 of the Constitution, it is provided that the High Court would exercise such powers most sparingly and only in appropriate cases in order to keep the subordinate courts within the bounds of their authority full stop. The power of superintendence exercised over the subordinate courts and tribunals does not imply that the High Court can intervene in the judicial functions of the lower judiciary full stop. The independence of the subordinate courts in the discharge of their judicial functions is of paramount importance, just as the independence of the superior courts in the discharge of their judicial functions full stop. The principle of justice, therefore, should be observed by all courts full stop. The Bangalore Development Authority, on 3.1.1977, issued a preliminary notification in terms of the Bangalore Development Authority Act, 1976 BDA Act for acquisition of certain lands, of which the land in question 2 acres and 34 guntas located in survey number 19/20 was a part full stop. The final notification was issued on 2.8.1978 full stop. However, non-finalization of the acquisition proceedings led to filing of a writ petition before the High Court full stop. The authority by resolution number 1084 dated 28.6.1988 denotified 1 acre and 12 guntas of the land in question full stop. The writ petition was withdrawn full stop. The appellant purchased the said land full stop subsequently, by a letter dated 30th August, 2001, the appellant was informed that the denotification resolution number 1084 had been withdrawn by the resolution number 325/97 dated 31.12.1997 full stop. The appellant filed a writ petition before the High Court seeking to quash the preliminary and the final notifications dated 3.1.1977 and 2.8.1978, respectively full stop. It was contended that the provisions of Section 11A of the Land Acquisition Act, 1984 were applicable to the BDA Act, and the award have been made after a period of more than 2 years from the date of declaration of the Act, the acquisition proceedings had lapsed. Full stop. Stop.